Good afternoon, Ms. Terry. How are you?
I'm well, thank you. Can you see me and hear me?
I can. Thank you so much. Appreciate that.
Yep.
All right. There's Mr. Gilmore. Good afternoon, Mr. Blankenship. How are you? Good afternoon, Mr. Gilmore. How are you doing?
Good afternoon. Hi. Well, thanks.
Perfect. All right. Got you all checked in. I see audio and video, so everything should be good to go when we do start.
Perfect. Thank you.
Thank you. Good afternoon, Ms. Harper. How are you?
I'm good. How are you?
Good. Just want to check audio and video, make sure everything was working before we begin.
Okay.
All right. Thank you.
Thank you.
Mr. Blankenship, are you able to activate video and unmute yourself, please? I'm going to send you a message to unmute, Mr. Blankenship.
Okay, I just unmuted, I think.
Okay, perfect. Thank you. Just want to check in, make sure audio and video were working. If you would like to, you can turn off your video and mute yourself. But when you are on video, we do ask that you remain stable so that it's not moving around. Okay.
Thank you so much.
All right. Thank you. Counsel, I do believe everybody you told me who's going to appear is on the screen right now. If you can just confirm that with me, I appreciate it.
This is David McElhaney. Yes, everybody I was anticipating is here.
All right, thank you.
Ma'am, we are awaiting one more. Mr. Sharp should be appearing any minute.
Okay, perfect. Thank you.
Ms. Clerk, we are apparently live streaming on YouTube. I don't know what that's about, but I don't know that. I just want to alert the court that somebody has activated that.
Yes, I have done that. Instead of increasing, that's what the court does, because somebody had sent an email, I don't remember right now off the top of my head, saying there may be several people in attendance.
Yeah.
So instead of increasing to 100, we do a live feed, so anybody can go onto the YouTube video or the link and be able to watch also, okay?
Fantastic. Thank you.
But thank you for bringing it to my attention. I appreciate it. Good afternoon, Mr. Gordon. Can you unmute yourself, please, sir?
Good afternoon, Your Honor.
Thank you. How are you today?
That's great.
All right. Are you expecting anybody else to attend?
Let's see, I think we have everybody.
Okay, perfect. Thank you.
Is Mr. Heimers here? I'm not sure. I don't see him.
No, I do not have him.
Okay.
And Mr. Sharp has not logged in either, counsel, just so you're aware.
Yes. Okay, so where's first? Enough to do it.
Ms. Clerk, this is Amy Terry. I
Yes.
understand that Mr. Sharp is having trouble with the Zoom link. Is there anything you can tell me to advise him to do?
If he goes to our website, washoecourts.com, and then there should be towards the top of the page, online hearings. And once you click on that, if you go down to Department 1, and then the link will be under the 3 o'clock. Oh, I see him now, actually.
Oh, great.
Let me try to bring him over. Mr. Sharp, are you able to activate video and unmute yourself, please, sir? Mr. Sharp, are you able to hear me? Mr. Sharp, can you hear me? Mr. Sharp, can you say something, please? Mr. Sharp? Mr. Heimers, are you able to activate your video and unmute yourself, please?
Yes, ma'am. Here I am.
All right. Thank you, sir. Just wanted to check, make sure everything was working before we begin. Thank you. Mr. Sharp, are you able to say anything yet? Ms. Terry, it sounds like I have some background noise for him, but I'm not able to have him speak.
He says that he's having trouble with his.
Can anybody hear me?
Yes, we can.
Hello?
Yes, Mr. Sharp, I can hear you. Can you hear me? This is the court clerk.
Testing?
Yes, Mr. Sharp, I can hear you. Ms. Terry, do you expect Mr. Sharp to be speaking today?
I believe Mr. Gilmore is handling the argument, and yes, I do believe he anticipates having Mr. Sharp testify.
Okay. Mr. Sharp, can you try saying something again for me, please?
Damn it!
I don't know if maybe you want to have him try logging off and logging back in.
I'll do that. I'll call him separately and explain what you explained to me so he can log in perhaps a different way. Thank you.
Okay. Yes, you're welcome.
course, when he curses, that's what you hear. Of course. Loud and clear, right? That was loud and clear. You heard that. I did anyway.
Unmute. Can anybody hear me? Okay.
Yes, Mr.
So you
Sharp,
just
are you able
can't
to
see
hear
me
me?
now.
Yeah, are you able to hear me, Mr. Sharp?
Barely, well, through the phone, my speakers, I don't know what's going on here. Just give me a minute and I'll try and figure it out. I'm sorry.
All right, thank you, Mr. Sharp.
Amy, give me a minute. Why isn't this working?
Mr. Sharp, are you using an iPhone or a computer?
Ms. Clerk, I think, oh, excuse me. This is Amy Terry. I believe that he could hear you, but he could hear you through the phone because I had called him. So I don't think
Oh.
he hears you. He hung up the call. So I can try again, but it sounds like we can hear him, but he can't hear us, and we can't see him and he can't see us.
Okay, if he's using a computer, maybe he can try using his phone and go to the Western Courts website, maybe?
I'll try that. I'll suggest it. I'm pretty confident he is using a computer. That's what he used last time.
Okay. All right, Mr. Sharp, I can see you now. Let's try unmuting.
Okay, now let me see if I can hear you. Can you hear me?
I can hear you. Are you able to hear
I can't
me?
hear you. Hang on. Try again.
Can you hear me now?
I can hear you. Thank you. Sorry about that. I'm not sure what was the problem.
No worries. Technology is great.
Yeah.
Is everyone ready to proceed?
Yes.
Ready to proceed for the defense.
Good afternoon, everyone. I am Judge Kathleen Draculich. I preside over Department 1 of the Second Judicial District Court here in Reno, Washoe County, Nevada. Let the record reflect that this proceeding is taking place July 7th, 2021 at 3 o'clock in the afternoon. This is case number CV21-00906, George Sharp versus Everlert, Inc., a Nevada corporation, and Doe officers and directors 1 through 20. Let the record reflect this hearing is taking place remotely because of the closure of the courthouse at 75 Court Street due to the national and local emergency caused by COVID-19. This court and all of the participants are appearing by simultaneous audio-visual transmission. I am physically located in Reno, Washoe County, Nevada, which is the site of today's court session. I'm now going to turn to representatives assisting Department 1 and Department 1 court personnel and ask that they each make an appearance for the record and indicate the county and state they are appearing from. I will begin with Department 1's court clerk, Ms. Lux.
Michelle Lux, Washoe County, Nevada.
Thank you. Department 1's law clerk, Ms. Davies.
Michaela Davies, Washoe County, Nevada.
Thank you, Ms. Davies. And our court reporter this afternoon, Ms. Murray.
Morning or good afternoon, Your Honor. Kate Murray, Washoe County, Nevada.
Thank you so much. The record should further reflect that this session of the court is available to the public for viewing and listening through a video audio link found at washoecourts.com. If at any time any of you who are participating here today cannot see or hear the other people participating in this proceeding, please immediately notify Ms. Lux. Counsel, I'm now going to turn to each of you, and when I do, I'd like you to make an appearance for the record. Tell me on whose behalf you are appearing, and then inform this court if you have received this court's notice of audio-visual hearing, indicating that these proceedings will be taking place pursuant to Zoom, that order being issued pursuant to Nevada Supreme Court Rule Part 9, pertaining to civil proceedings, and pursuant to the administrative orders issued by this court in 2020 and 2021 pertaining to COVID-19, and inform this court, do you have any objection to going forward in this manner? Mr. Gilmore, I'll begin with you.
Afternoon, Your Honor. Frank Gilmore appearing for the plaintiff, George Sharp. I am located in my office in Reno, Nevada. I have received a notice of the audio-visual hearing and the statements contained therein, and plaintiff and his counsel appears without objection pursuant to those regulations.
Thank you so much. Mr. Mushkin.
Good morning, Your Honor. Good afternoon, Your Honor. Yes, I've received it and we also agree.
Okay, thank you so much. What county and state are you appearing from?
Sorry,
Mr.
Las
Mushkin?
Vegas, Nevada, Clark County.
Thank you so much. And
I'm
Ms.
tying
Tierney,
my tie. I got late notice on the dress code.
that's all right. And on whose behalf are you appearing?
Mr. Sharp, I'm along with Mr. Gilmore.
Thank you so much. Ms. Terry, you're next. In addition to everything I've asked counsel to do thus far, if there's anyone participating by way of client, witness, et cetera, on behalf of plaintiff in this case, would you please introduce them as well?
Yes, Your Honor. This is Amy Terry. I'm appearing in Washoe County, Nevada. I'm appearing for the plaintiff, George Sharp, who is also present with us today. Mr. Sharp is, and we have received, as Mr. Gilmore said, the court's order regarding appearance via Zoom, and we have no objection. And Mr. Sharp, I believe, is in his office in Scottsdale, Arizona.
Ms. Terry, thank you so much. Good afternoon, Mr. Sharp. Are you appearing from Scottsdale, Arizona, sir?
Good afternoon, Your Honor. Yes, I'm appearing from Maricopa County, Arizona, in the city of Scottsdale.
Okay, thank you so much.
Thank you.
Mr. McElhaney.
Good afternoon, Your Honor. David McElhaney on behalf of defendant Everlert, Inc. Joining me is my partner, Brian Blakely. Although he will not be participating, I think he's here just in case I start stammering or say something stupid. Mark Blankenship is here. Jennifer Harper is here. They are both representatives, officers, and directors of the corporation Everlert.
Okay, thank you so much.
And Your Honor, forgive me, I'm in Washoe County. I apologize.
Thank you so much. Mr. Blakely, sir, are you appearing from Washoe County, Nevada?
Sorry, Your Honor, I'm appearing from Clark County, Nevada. I'm in Las Vegas today.
Thank you so much. Ms. Harper, can I get your location, please?
Los Angeles, California.
Thank you so much. Mr. Blankenship.
Los Angeles, California.
Okay, thank you so much. All right, next, Mr. Gordon.
Yes, hello, Your Honor. Richard Gordon, bar number 9036. With Snell and Wilmer, we represent the intervener, Mr. Robert Heimers. And we did receive notice that this would be an audiovisual hearing, and we consent to that. I am appearing from my office in Clark County, Nevada, and we're ready to proceed.
Okay, and Mr. Heimers is here as well.
That is correct. Mr. Heimers is present.
Good afternoon, Mr. Heimers. Where are you appearing from, sir?
Good afternoon, Your Honor. I'm in downtown Los Angeles at the moment.
Okay, thank you so much, Mr. Heimers. All right, everyone. By way of background, On June 3rd, this court issued its order granting an emergency motion for appointment of custodian pursuant to NRS Chapter 78.347 and for temporary restraining order and mandatory injunction relief. I'm going to refer to that throughout this proceeding as the custodianship order. This court appointed Plaintiff George Sharp as custodian of defendant Everlert Inc. pursuant to 78.347(3) of the NRS. The custodianship order also entered a temporary restraining order, a mandatory preliminary injunction requiring Everlert to turn over all books and records to Mr. Sharp. Thereafter, Everlert filed a motion to set aside the order granting emergency motion for appointment of custodian, or alternatively requiring payment pursuant to NRCP 65C. That was filed on June 24th of 2021. Therein, Everlert seeks to set aside the custodianship order. On June 25th, 2021, Everlert also filed and submitted to this court for its consideration a motion for temporary restraining order and request for hearing on defendant's ex parte motion for order shortening time. In that motion, Everlert seeks to restrain Mr. Sharp from taking any further action under the custodianship order until this court rules on Everlert's motion to set aside. On June 25th, Mr. Sharp filed his opposition to that motion and request that this court deny that motion. I then set this hearing for today's date and time. Thereafter, I received, and while this hearing was originally set for the hearing on the custodianship order, thereafter, I enlarged the scope of the hearing to include Everlert's motion to set aside and Everlert's motion for temporary restraining order. And most recently, the court has received the filing of intervener Robert L. Heimers, his motion to intervene. That was filed on June 30th of 2021. Mr. Heimers also filed a proposed intervener's motion for an order shortening time. And this court most recently indicated that it would hear the motion regarding his proposal to, or his request to intervene today. This is how it's going to go this afternoon, counsel. You can call your witnesses throughout these proceedings as you deem appropriate, but this is how I would like it to proceed today with regard to oral argument, so that this court can keep an accurate and linear transcript of these proceedings. Plaintiff will first present its argument in support of its emergency motion for appointment of custodian and for temporary restraining order and mandatory injunction relief, which is required by statute. Then the defendant will present its opposition. That's the custodianship motion. The defendant will then present its opposition to the custodianship motion and its oral argument in support of its emergency motion for temporary restraining order and request for a hearing, and its argument in support of the order grant and its opposition to the order granting emergency motion for appointment of custodian. Plaintiff will then reply regarding its motion for temporary restraining order, that is the custodianship order, and will present its response or opposition to defendant's motion to set aside and defendant's motion for a TRO, and then defendant will reply regarding its motion to set aside and its motion for a TRO. And then Mr. Gordon is going to present his argument regarding the motion of Mr. Heimers to intervene, and I'll hear oppositions to that motion. Mr. Gordon is going to get the last word on that motion since he is the proponent. With that, Mr. Gilmore, I think I heard Ms. Thierry say that you are going to be taking lead argument for Mr. Sharp with regard to today's proceedings. So I'm turning to you.
That's correct. Thank you, Your Honor. I'll be presenting the arguments in favor of the custodianship order and against the motion for temporary restraining order filed by the defendants. Mr. Mushkin will be addressing the arguments associated with the interveners.
Mr. Gilmore, I know you may not have intended to include this. There are timing issues here for the court regarding whether or not and to what extent. I've not heard anything. I mean, I've read all the pleadings, I've read all the exhibits, but I want you and Mr. McElhaney or whoever is going to address the oral argument on behalf of defendants, please explain to me what is exhibit, just put this on your list. You don't have to do it at the outset, but at some point during the hearing, I would like both parties to explain to this court what Exhibit 7 to Everlert's notice of defendant's proposed exhibits for today's hearing, which was filed July 6th of 2021. It's Exhibit 7. It's the email from Nancy Rodriguez at OTC Markets. I want both parties to explain to this court, what does that mean globally with regard to what Mr. Sharp can and cannot do? Mr. Gilmore, I'm going to give you just 60 seconds. Open up that exhibit so that you can take a look at it. Okay, I know
I
you
have it
looked
in
at
front of me, Your Honor.
Yeah, there are a lot of exhibits in this case. I don't want to throw something at you and force you to take an off ramp when you've probably got a very organized argument. So at any time during the proceeding, I want counsel to talk to this court about what this means as I think through what it is I'm going to do and what Mr. Sharp is entitled to continue to do or not be allowed to do as a result of this letter, okay, or email. If you look like it's an email. All right. Okay. With that as the backdrop, Mr. Gilmore.
Thank you, Your Honor. Let me take that Exhibit 7 first up, because I think we can use that to provide some backdrop to the dispute, and we can utilize Exhibit 7 to discuss the current status of events as it pertains to the defendant's motion for TRO. For purpose of background, OTC Markets Group provides a portal whereby over-the-counter traded public corporations who are not listed with the registered stock market, NASDAQ, New York Stock Exchange, OTC Markets provides the portal whereby disclosures can be made by officers of these corporations to inform investors of the status of the operations, the profitability, et cetera, of these corporations. That's the function of OTC Markets. The reason Exhibit 7 is pertinent to today's conversation is because in 2020 September, effective 60 days later, there was a rule amendment as it pertains to the disclosure requirements for OTC traded corporations. And OTC has three different, I won't get into the depth of it, but OTC has essentially three different subsets of publicly traded corporations, one of which is called the pink sheets. The rule that was initiated, the rule change that was initiated by the Securities and Exchange Commission essentially made more stringent requirements for OTC traded corporations, particularly pink sheet corporations, to make more public disclosures about the profitability, the financial conditions, the debts, et cetera, associated with these OTC corporations. More aligned to what the SEC requires of publicly traded corporations that are on centralized stock exchanges. The OTC Markets had set what we'll refer to, Your Honor, as essentially a soft deadline of June 30. The soft deadline required OTC traded corporations to submit an application for access to the OTC Markets portal. The portal is, for lack of a better word, it's kind of like the eFlex, the court's eFlex system, where if you have an account, it authorizes you to be able to publish records associated with the corporation that are then accessible to investors, stockholders, et cetera. The applicant to the OTC Markets under this rule is the person that's given authorization to upload these disclosures through the portal, which are then accessed by members of the public. The reason why this application for appointment of custodianship, I think we lost the judge. Oh, there you are.
No,
Sorry,
I'm
Judge.
right here. No, wait, let's make sure we didn't, who did we lose?
We lost somebody.
I have Sharp, Gilmore, Thierry, Mushkin, McElhaney, Blakely, Mr. Blakely, there you are. Harper. There she is. Blankenship. There he is. Mr. Gordon. Mr. Heimers. Okay, go ahead, Mr. Gilmore.
I'm sorry, Your Honor, that threw me off too.
We lost Mr. Mushkin.
Oh, he's back.
Oh,
I
I'm
see him.
sorry. I see him. Okay, go ahead.
The rule that was put in place that was approved in September of 2020 and effective 60 days later requires corporations which wish to be active on the OTC, we'll call it a market, but the OTC system has to make these disclosures, has to make an application to be permitted to have access to the portal in order to provide these publicly available financials to the public. And the firm deadline for the application to be approved by the OTC markets is September 28, 2021. The reason this case commenced was when Mr. Sharp reached out to Everlert's former management and inquired about their intention to ensure that Everlert was endeavoring to meet the soft June 30 deadline to submit their application in order to be processed, because we've been told by OTC markets that there's approximately a 6 to 8 week time frame for the application to be reviewed and approved so that the corporation can have access to the portal. The representation by OTC markets is that if the June 30 deadline is not made, there's no guarantee the application would be approved by the end of September. If the application were not approved by the end of September, that could be fatal to the ability of the corporation to continue to trade OTC. So on May 4, Mr. Sharp sent an email to Mr. Blankenship and asked him about his intention and management's intention for Everlert to ensure that this deadline was met. There were other inquiries in that email about intention to reinstate the corporation at the Nevada Secretary of State level and other issues associated with the lack of any financial disclosures from the corporation dating back to 2018. Mr. Sharp sent that email. He did not receive an email, but 3 days later, he received a telephone call from Mr. Blankenship where the substance of that email, which is, we'll review in some few minutes, Exhibit 1 to plaintiff's presentation, is the email. That was on May 4. Mr. Blankenship called Mr. Sharp on May 7, and they had a conversation discussing the substance. The substance of that conversation, as will be established in the testimony, is that Mr. Sharp introduced himself as a concerned shareholder and inquired about the management's intention to ensure that an application were made to OTC markets to ensure that the September deadline were made that would not impact the ability of the stock to trade. Summary of that conversation was effectively that Mr. Blankenship indicated that he had no inclination to do as Mr. Sharp had requested. Mr. Sharp said, if you don't do these things within the next week, then I will take it upon myself to seek custodianship under Nevada law, in which I will take it upon myself to ensure that the application is made, that the books and records are taken into my possession, that the financial statements are prepared, and that they are uploaded through the portal so that we have no possibility of having the trading impacted by the September 30 deadline. The complaint and the emergency motion for appointment of the receiver was filed on 13 May and was served upon the registered agent of the corporation on 14 May. Those facts are undisputed. When no response to the emergency motion had been received within 19 days of the filing of the motion, plaintiff submitted the request to have the court enter the custodianship order, which was entered on June 3. A point of contention that the court has likely read and that the court will likely be concerned about is this contention that there was some misrepresentation or fraudulent inducement by the plaintiff and his counsel to induce this court to enter an order based on falsified facts or facts which plaintiff and his counsel knew not to be true. Let me address that. In the motion, emergency motion to appoint a custodian, several issues were raised. Among them were the fact that the corporation's management, we'll say former management for purposes of today's order, but former management had not filed annual lists and secured the business license associated with the requirements under Nevada law since February of 2018. In other words, the status of the corporation had been revoked under Nevada law as represented in the Secretary of State's online portal. Additionally, there had been no financials made available to the public since December 31st of 2018. Those issues, in addition to the fact that because no financials had been made publicly available, OTC Markets had put what we colloquially refer to as a stop sign on the trading, which does not, for lack of a better word, delist the stock, but it does notify the investors that this is likely to be a defunct or dark corporation, which obviously has a substantial and material impact on the tradability of this stock. When Mr. Sharp submitted the motion to have the order entered, former management of Everlert had reinstated the corporation. We don't deny that. Mr. Sharp was aware that the corporation had been reinstated, but the motion for appointment of the custodian was submitted in light of those facts. And the dispute is that although the corporation had been reinstated, that was only one of 2 or 3 bases upon which the order was to be entered. And the plaintiff's position is that the foundational reason for the custodianship has less to do with the technicality of the corporation being in revoked status and had more to do with the fact that there was no intention, at least no apparent intention, on behalf of the corporation's management to ensure that the OTC Markets application and the firm September deadline were intended to be met. And so in addressing this contention that a request for submission was filed which contained false and misleading information to induce this court to enter an order, that's simply not true. The motion was seeking a custodian to ensure that the June 30 deadline was not blown, that then prevented the ability of the corporation to be current with the OTC Markets application so that the September deadline could be made. In fact, the order that the court entered that was presented to the court and submitted to the court and then entered actually makes no reference whatsoever to the default status of the corporation. Indeed, the order specifically refers to the problem of ensuring that the OTC Markets application was current and prevented any impact on the tradability of this stock come September. The position that the plaintiff takes today with respect to the viability and necessity of the order is that defendants showed no intention to ensure that they met the deadline, and when plaintiffs secure the custodianship, the evidence will show, if necessary, to be presented through Mr. Sharp and the exhibits, that Mr. Sharp took it upon himself to make the application to the OTC Markets. He submitted the necessary paperwork. Exhibit 7 that the court has referenced is something that we had also disclosed in our exhibits to the hearing. Essentially, Nancy Rodriguez, being one of the compliance officers of OTC Markets, is explaining here that there has been an application made by Mr. Sharp, but the application is pending review because OTC Markets is not in a position to be able to finalize the review of this application while there is a control dispute pending. I do not believe these facts are in dispute. I think what Mr. McElhaney will say is exactly what I will say, and that is that as a result of the custodianship order, as a result of Mr. Sharp's application, as a result of the opposition provided by the defendants, by management, to Mr. Sharp's custodianship, that has put OTC Markets in a position where they cannot refuse nor approve the application. It will be effectively, Your Honor, in a holding pattern until there is some resolution of the control dispute of Everlert. That's my understanding of Exhibit 7, and we had provided emails in our exhibits effectively with the same understanding that the application, while it's been submitted, and as far as we know, the application is complete, it cannot be finally and formally approved until the court has resolved the dispute associated with the management.
How does it impact the ability to trade the shares?
It presently does not impact the ability to trade the shares. The impact has to do with the 6 to 8 week application review period, whereby if OTC Markets is not given sufficient time to be able to review the application prior to the September deadline, then the trading could be impacted. At this point in time, our position is that Mr. Sharp did what was required to be done, which management failed and refused to do. And as a result of that application, if the court were to enter an order resolving the control dispute, Mr. Sharp's application, we have every reason to believe, will be approved. And then Mr. Sharp, if the court grants him the permission to do so, would have the ability to have the financial statements prepared, reviewed, have an attorney opinion letter issued, and have those statements uploaded through the portal to be in compliance by the September 30 deadline. That's our position with respect to what Exhibit 7 means and how Mr. Sharp has addressed that. Let me, if there's no questions, then Your Honor, with respect to Exhibit 7.
Your Honor, you want me to respond to Exhibit 7 or just let Mr. Gilmore finish up?
Let Mr. Gilmore finish up, please. Thank you. Mr. Gilmore.
Thank you. Your Honor, what I understood the court to say in terms of the course of the proceedings was first for us to address the substance of the emergency motion, which led to the custodianship order. And then from there, Mr. McElhaney will address his motion to seek TRO relief to enjoin the enforcement of the order, and we'll go in that order. So if I heard the court correctly, let me just simply hit the high points of the motion that resulted in the custodianship order, most of which I have already touched on, but let me set those out in order. The first position associated with the complaint and the petition for custodianship was the fact that the corporation was in default status, had been revoked at the Secretary of State level, and no annual list had been submitted since February 28 of 2018. The second basis upon which the custodianship was requested had to do with this OTC application. And based on the conversations Mr. Sharp had with Mr. Blankenship, it was apparent to Mr. Sharp that Mr. Blankenship and management had no ability or desire to ensure that the application were made. Indeed, the evidence we believe will show is that neither Mr. Blankenship nor Mrs. Harper actually intended to make the application, likely because they knew that their application could not be approved. So when Mr. Sharp was advised that through his conversations with Mr. Blankenship that likely that no application would be made, he took it upon himself to do so. The complaint and the emergency motion were served upon the registered agent of the corporation on 14 May. The defendants acknowledged that the registered agent was served. The defendants take the position that personal service of their registered agent is insufficient to put them on notice of the existence of the motion, and therefore they contend that they were deprived of due process. We can address that in response to Mr. McElhaney's motion for TRO, but the fact is that, and it's undisputed, on May 14, the registered agent was served. The motion was submitted 19 days later, and the order was then entered. Subsequent to the entry of the order, Mr. Sharp will testify as to the actions he's taken consistent with the compliance of that order, which included, among other things, negotiating and reducing the balance. The corporation had a significant, in excess of $25,000 invoice owed to its transfer agent, which Mr. Sharp negotiated and has taken care of. Mr. Sharp retained a registered agent on behalf of the corporation. Mr. Sharp made the application to the OTC Markets, which is one of our exhibits, and Mr. Sharp made the necessary filings with the Secretary of State that NRS 78 requires. Our position is, Your Honor, that when the custodianship order was entered, it was justified by virtue of the fact that the management had shown no intention of making publicly available financial statements and had no intention of ensuring the June 30 deadline would be met so that the application could be approved and no suspension of the trading by the end of September. If the court has no further questions,
I do
that
have
would be
one.
the presentation I would have with respect to the emergency motion, the order granting the custodianship, and the efforts of Mr. Sharp subsequent.
Mr. Gilmore, you made a statement that that even if the Harper Blankenship OTC application had been submitted, it would not. It was the belief of Mr. Sharp that it would not be approved. Why?
In Exhibit 15, which was an exhibit that we lodged in anticipation of the hearing.
Let's make a record of that on subsequent to the filing of plaintiffs exhibits 1 through 13, which occurred on July 1st, 2021. Plaintiff lodged exhibit number 15 on July 7th, 2021. It's entitled Supplement to Proposed Exhibits submitted by plaintiff for July 7th hearing. This is a several page document, Exhibit 15, which starts out OTC Markets background check authorization form. Mr. Gilmore.
Thank you, Your Honor. To give some context to Exhibit 15, attached is Exhibit 11, which was one of the original exhibits that we submitted on Friday, is an email of June 28 from the issuer services of OTC Markets evidencing the receipt of Mr. Sharp's application. That indicates, thank you for submitting your OTC IQ order form and documents. Next, the team will send you an invoice for both the application and subscription fee. And the court will see that in that email chain, on page 3 of that email chain, at the bottom, shows the submission that Mr. Sharp made to the issuer services as part of his application.
This is the email from Mr. Sharp to issuer services. That's part of Exhibit 11 that's dated Tuesday, June 22nd, 2021 at 3:19 p.m.
That's correct, Your Honor.
Okay, go ahead.
Attached to that email are identification of a number of documents which Mr. Sharp submitted to issuer services as part of his application. It includes a custodianship it includes the application form, included the order of the custodianship, and various Secretary of State documents. And then number 4, Your Honor, is the background check authorization. Background check authorization that's referenced in Exhibit 11 is Exhibit 15.
Right.
The reason why we submitted Exhibit 15 is because Mr. Sharp will testify that both in his personal capacity as a consultant to OTC Markets and in his personal knowledge, consistent with the requirements of this Exhibit 15 background check authorization form, on the second to last page of Exhibit 15, there is required disclosures about the applicant's legal and disciplinary history as it pertains to criminal convictions, disbarments, suspensions of business or securities activities, those kinds of things. And it is our expectation to be able to establish, perhaps not today, because we haven't had the opportunity to do a full scope of discovery in anticipation of a substantive evidentiary hearing, but it is our expectation that one of the reasons why the application was not submitted by defendants is because they could not have passed a background check that would have enabled OTC Markets to approve that application.
All right, that was my question. Mr. Gilmore, before I turn the podium over to Mr. McElhaney, is there anything else you want to present to the court in your case in chief regarding the plaintiff's original motion for a temporary restraining order and injunctive relief, including presenting testimony through Mr. Sharp?
evidentiary presentation of the case that I had anticipated was in response to the opposition, in support of the opposition of the motion for TRO. But much of the presentation that I had intended to offer with respect to Mr. Sharp actually would support the application for the entry of the custodianship order. So if the court is willing to allow me to make my presentation with Mr. Sharp now, I'd like to do so.
Let's do that. Mr. Sharp, Ms. Lux, who is our court clerk, is going to swear you in. Ms. Lux.
Mr. Sharp, please raise your right hand. Do you solemnly swear that the testimony you're about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Thank you, Mr. Sharp. Mr. Gilmore, your witness.
Thank you. Mr. Sharp, would you please identify yourself by stating your full name and spell your last name for the record?
George Andrew Sharp, S-H-A-R-P.
And Mr. Sharp, would you please give us the benefit of your relevant background as it pertains to the issues at hand?
I've had a career of over the last 15 years of whistleblowing against bad actors in the microcap market, which primarily whose stocks primarily trade on OTC markets. I had a website that exposed such bad actors and dubious companies, public companies. That website was purchased by OTC Markets from me, who then subsequently retained me as a consultant for a period of 1 year to work with their market data and compliance departments in hopes of strengthening their compliance requirements to eliminate microcap stock fraud.
Mr. Sharp, what's your current occupation or profession?
I'm a consultant to public companies, attorneys, and I continue to whistleblow privately, but most of my work is in advocating for shareholders and rescuing public companies and merging them with performing assets.
Mr. Sharp, are you a stockholder of Everlert?
I am.
How many stocks do you currently own? How many shares of stock?
I believe it's either 300,000 or 400,000 shares. It might be 500,000, as I recall. As I sit here, I don't recall the exact number.
Mr. Sharp, do you have available to you Plaintiff's Exhibit 1 that was submitted in anticipation of the hearing today?
I believe I do.
Mr. Sharp, if I could, just a minute, I want to make sure we're clear. What Mr. I want to set the record. Mr. Gilmore is referring to the exhibits that plaintiff filed in this case on July 1st. These are not the exhibits that were attached to the original complaint, because there is an Exhibit 1 attached to the complaint. But under the cover sheet submitted by Ms. Terry is the proposed exhibit submitted by plaintiff for the July 7th hearing filed July 1st of 2021. So go ahead, Mr. Gilmore. Thank you.
Thank you, Your Honor. Ordinarily, we might share the screen to enable group access to these exhibits. I know that's been disabled. My expectation is that all the participants have been given access by way of service of these exhibits. So
it may be possible to share the screen if you want to do that, Mr. Gilmore. Ms. Lux, can we enable that?
It is enabled, Your Honor. Thank you.
Mr. Gilmore, you want to try and do that? If not, I can try and have Department 1's law clerk, Ms. Davies, do that.
Your Honor, I believe I can do that.
Okay, there you go. You're doing it.
Thank you. You never know until you've done it. Mr. Sharp, I would direct your attention to the screen which I've just shared.
Go ahead and open Exhibit 1.
Mr. Sharp, can you see Exhibit 1 on your screen?
Right now, all I see is a list of exhibits.
Okay, I have got it on my screen. I don't know why it's not shared.
Mr. Gilmore, the way it appears right now is we've got we've got a list of files on the left, then we've got all the exhibits listed in the center, and then off to the right is Exhibit 1. So it's not, it's I can see a piece of the exhibit, in small format.
Yeah, let me see if I can do this.
Your Honor, while Mr. Gilmore's working on this, I wanted to alert the court, this is Brian Blakely, that Mr. McElhenney has lost his connection. He is trying to log back in now.
We're gonna work on getting this exhibit on screen, Mr. Blakely, and then we're not gonna go forward until Ms. Lux tells me that Mr. McElhenney is back on screen.
Perfect.
Your Honor, is Exhibit 1
There
now
you
showing?
go. You did it. You got it. Okay.
What I have to do is I have to open them individually.
Okay, let's wait for Ms. Lux to tell us that Mr. McElhenney is back with us.
Your Honor, may I request that Mr. Gilmore stop share screen just so that I can check the attendees list? I'm not able to see it while share screen.
Of course.
Thank you.
Back. Now the screen is frozen again.
There we go. Hi, Mr. McElhenney.
Your Honor, I think we're having internal problems at my office, but for now, it looks like I'm okay. Apologize to the court.
That's all right. We can see and hear you. Okay, Mr. Gilmore, go ahead. Mr. McElhenney, let me suggest this, Mr. Blakely, if you lose service again or you can't hear us, just email your colleague and then he'll immediately inform us.
All right. I'm
Okay.
definitely having problems, but right now we're so good. We're good.
Nope. Okay, there we go. All right, Mr. Gilmore, go ahead and screen share that exhibit 1.
Okay. Can everybody see this?
Yes.
Mr. Sharp, do you recognize this document which has been identified as Plaintiff's Exhibit 1?
I do.
And what do you recognize it to be?
It is an email that was sent to Mr. Blankenship on May 4th, informing him that I had an intention to petition for custodianship of Everlert unless he informed to me of his intention to bring the corporation current and file the OTC Markets required disclosures.
What was the purpose of this email?
The purpose of this email was to protect the shareholders of Everlert from having their shares become valueless.
In the second sentence, you say, among other things, you have allowed the corporation to be revoked by the Nevada Secretary of State and failed to file disclosures through OTC Markets, including financials and attorney opinion letter. Could you describe what you mean by filing disclosures through OTC Markets?
Okay. OTC Markets is the platform, provides a platform through which stocks like Everlert, which are considered to be microcap or penny stocks, most of them do not report to the United States Securities and Exchange Commission. They provide the platform on which these stocks are electronically traded. OTC Markets has its own policies and practices through which issuers such as Everlert are required to file quarterly financial reports, amongst other disclosures. And with each annual report, an attorney opinion letter must be uploaded in which the attorney attests to the accuracy to the best of his ability of the annual report and the other assertions made by the corporation and its officers and directors.
How is it that you have personal knowledge of these requirements?
I was a consultant to OTC Markets for about a year, and I was a retained consultant for that matter, paid. And I've spent 15 years advocating for shareholders, consulting to public companies, attorneys, etc.
You then indicate to Mr. Blankenship, you have 48 hours from the date and timestamp of this email to respond to me in such a way that encourages me to believe that you will fulfill your obligations to the shareholders of Everlert, Inc. Do you see that?
I do.
What obligations, in addition to the previous paragraph, does that identify all the obligations that you believe Everlert management was deficient in accomplishing?
In a general sense, yes, there are other sub-requirements. For example, a registered agent must be retained and paid for, as well as a transfer agent who maintains the books and records of the share issuances. These must all be in good standing.
Did you receive an email response to Exhibit 1?
I did not.
What was your next contact or communication with anyone of the former management of Everlert?
On May 7th, I believe, I received a phone call, early morning phone call from Mr. Blankenship.
And what did Mr. Blankenship say to you?
Mr. Blankenship was quite agitated with me and assured me that he was Everlert's biggest shareholder by far, and that he would dispute any custodianship petition I intended to file.
What did you say to him?
I assured him that there was no need to oppose any custodianship petition, because provided that I believe I gave him the deadline of the following Wednesday or Thursday, provided that he filed to bring the corporation current and showed that he had made his application to OTC Markets, I would not be filing my custodian petition.
Your Honor, sorry to interrupt. I believe we lost Mr. McKelney again.
He is working to get back on right now and on what I hope is a different connection. Our Reno office is having some sort of internal internet issue. He'll be back on as soon as he possibly can be.
All right, Mr. Blakely, we'll hold on. Very
Thank
important.
you.
Yeah, and I'm going to figure out what the last thing he heard Mr. Sharp say, and we'll have him repeat that.
Thank you so much, Your Honor. Many apologies.
Hi, Mr. McElhaney.
Your Honor, can you hear me?
I can.
I apologize for the distorted image. I changed computers, hopefully have eliminated the signal problem.
Actually, no distorted image. Tell me, what was the last thing you heard Mr. Sharp say?
Your Honor, I think he was going through his credentials, and we were talking about his exhibit, the warning that he had sent to my clients that unless they got current within 48 hours, he was going to file an action.
Okay, so you got as far as Mr. Blankenship calling him on May 7th?
I did not hear about the phone call. I think they were still talking about the email that he had sent.
Okay, Mr. Gilmore, if I might ask you to have or make an offer of proof as to what Mr. Sharp said regarding the May, whether or not, let's start with this, whether or not he got an email in response to Exhibit 1.
I'll go back to that and re-ask those questions, Your Honor. Mr. Sharp, did you receive an email response from anyone at Everlert in response to Exhibit 1?
Did not.
When was the next time you heard from anyone purporting to be in the management of Everlert?
It was, I believe, on the early morning of May 7th, when I received a telephone call from Mr. Blankenship.
And what did Mr. Blankenship say to you?
Mr. Blankenship was quite agitated with my email and informed me that he was Everlert's biggest shareholder by far, and that he intended to oppose any custodianship petition that I intended to file.
Did he identify his role at Everlert during this phone call?
As I recall, he only identified himself as Everlert's biggest shareholder.
Okay. At the time, did you understand, what did you understand Mr. Blankenship's role to be at the management of Everlert?
Well, Mr. Blankenship was listed as a CEO and a director of the company.
And what did Mr. Blankenship tell you was his reason for opposing your custodianship?
He didn't give me any reason outside of stating that he was the company's biggest shareholder.
Did you ask him if he intended to ensure that the OTC Markets application were timely made?
What I stated to him was that there was no need to oppose any petition, as if he were to show by the following Wednesday or Thursday it was, that he had reinstated the corporation and filed, if he could show he filed an application with OTC Markets, that I would not be filing my petition.
During that phone call, did he say anything to you which gave you the impression that he intended to file an application with OTC Markets?
Absolutely not.
Did he specifically tell you that he was not intending to make an application to OTC Markets?
He did not state that either.
And was there anything else of substance discussed between the two of you during that call?
Only that he was going to oppose my petition.
And did you give him during that phone call, did you give him a deadline, so to speak, of when you would request that these two items be addressed?
Yes, he called me on May 7th, and I believe I told him that if he could show me that he reinstated the corporation by the following Wednesday and had filed the application to OTC Markets, I would not file the petition. And then I actually waited until the following Thursday.
And so the following Thursday, May 13, what did you do?
I instructed counsel to go ahead with the petition filing.
Would you please tell the court why you decided to file the complaint and the petition for custodianship?
I've been a longtime advocate for shareholders, and as a shareholder myself, I wanted to ensure that the shareholders were protected from the pending deadline issued by the SEC as we've discussed previously, and the soft deadline set by OTC Markets for applications to be submitted.
You heard my representation to the court regarding the application deadline, the 6 to 8 week delay, those sorts of things. You heard my representations to the court, did you not?
Yes.
Did you hear anything that I said which was inartful or inaccurate that needs a correction?
Nothing that needs a correction, maybe an addendum, but not a correction.
I'm sorry?
Maybe an addendum, but not a correction.
Look at this, my picture.
What about the OTC Markets application do you believe it's imperative today for the court to understand as evaluation of this custodianship order?
The application the processing of the application needs to continue because if the financials are not filed and it's submitted for review by OTC Markets in time, then the corporation is in danger, certain danger of being suspended by the Securities and Exchange Commission.
Since the entry of the custodianship order, what have you done to put yourself in a position to be able to ensure that these compliance requirements and deadlines are met?
I've retained and paid for a registered agent to bring the Nevada Secretary of State up to date and ensure that we have an agent for service of process. By we, I mean the corporation Everlert. I negotiated the arrears with the transfer agent and paid the negotiated amount. I believe I negotiated a 60% discount to the arrears. And brought the transfer agent in good standing, and have retained securities counsel for Everlert and paid a retainer to securities counsel, and I have filed the application with OTC Markets, a timely application with OTC Markets.
What role would the Securities Counsel play in the OTC Markets application or subsequent uploading of the financials?
Well, the securities attorney would have to issue an opinion letter as to the validity of the disclosures, the delinquent disclosures, and any new statements made to OTC Markets. And then there'd be a lot of hand-holding to make sure that we did everything in the proper manner.
Mr. Sharp, do you have available to you Exhibit 5, Plaintiff's Exhibit 5?
Are you? I'm having computer issues. Are you going to post it? There we go.
Oh, how do I do this now?
There you go. Tab at the top there.
Yeah, I have to move the little Zoom thing out of the way so I can do that. Mr. Sharp, can you see Exhibit 5 on the share screen?
I see the title page for Exhibit 5.
Thank you. I'll direct your attention to an email sent by Ms. Thierry to Mr. McElhaney and Defendants Counsel of June 22, 2021. Ms. Thierry reports to Mr. McElhaney and Mr. Blakely in the bullet points here, I'll direct your attention, that you have been in communication with the stock transfer agent. Is that correct?
That is correct.
Have you already testified as to everything that you did and accomplished with respect to the transfer agent?
Yes, and in addition to that, I received paid for a shareholder list, which was required to be submitted to OTC Markets.
In the third bullet point, Ms. Thierry notifies Mr. McElhaney that you had made the application to gain access to OTC IQ. That would be the OTC Markets portal, correct?
That would be correct.
And then in the last paragraph, Ms. Thierry indicates that a request for the Everlert books and records had been made. That's correct to your understanding?
That is correct to my understanding.
And what would be the purpose and necessity for the turnover of the books and records as it pertained to this OTC application and attending deadlines?
So that Everlert's accountant could glean whatever information he needed from them to complete up-to-date financial reports as would be required by OTC Markets.
If the court today were to enter an order enforcing the custodianship order that requires the defendants to turn over the books and records, would that enable you to be able to prepare and upload the financials as required by the new SEC rule?
Yes, me and the accountant that has been retained on behalf of Everlert.
And what preparations have you made to be able to ensure that you would be able to do that?
File the OTC application for access to the OTC IQ portal and retained an accountant.
Mr. Sharp, the court had questions about Defendant's Exhibit 7, which is the email from Nancy Rodriguez.
Yes.
Have you had a chance to review that?
I have.
Mrs. Rodriguez says, be advised there appears to be a control dispute for Everlert Inc. involving Mr. Blankenship and George Sharp. Please note that it is OTC Markets Group's policy in the case of a control dispute to disable the OTC IQ account until the dispute has been resolved. What is your understanding as to the ramifications of that representation by Ms. Rodriguez?
If the corporation does not have access to OTC IQ, it will not be able to submit its disclosures, which include the financial reports. And in the long run, it will not be deemed current by OTC markets, which will subject it to suspension by the United States Securities and Commission, United States Securities Commission on September 28th or after.
What's your understanding of the detriment to the corporation if that deadline is not met?
If the deadline is not met, trading in the shares of Everlert will be suspended for a period of 10 days. The stock will be then relegated to the gray sheets. In simplistic terms, as much as it's possible to put in simplistic terms, the shares of the corporation will not be able to be traded through the control of a market maker. There will be no ability to fund the corporation because the shares will become unattractive to any potential funders. And the share price, through my experience, will head quickly towards zero.
And Mr. Sharp, can you see my screen where I put on Exhibit 13? Is that showing?
I see Exhibit 13. Let me see if I can get it bigger. If you could scroll back.
Plaintiff's Exhibit 13.
That's correct, Your Honor.
Go ahead, Mr.
Yes, I see
Gilmore.
what you're showing now.
Mr. Sharp, can you identify this exhibit and what it is?
This is the directive or from OTC Markets that companies who wish to be deemed current by the SEC's deadline of September 28th should submit their applications by June 30th.
Direct your attention to the paragraph shown at the top of the screen. The upcoming implementation of amended SEC Rule 15C2-11 will require that all companies quoted on our markets must disclose current information on a continuous basis, effective September 28, 2021. What's your understanding as to the current information that this paragraph is referring to?
A current list of the share structure, the officers and directors, and quarterly and annual financial reports.
And then directing your attention to that last paragraph. Impacted Pink companies should provide the required disclosures to OTC Markets by June 30th. This will ensure that our issuer compliance team has sufficient time to review and update market status for companies prior to the rules compliance data on September 28th. That's consistent with your understanding of the requirement?
Yes, this paragraph states that not only does the application have to be submitted by June 30th, but the required disclosures should be submitted by June 30th. I would state that this paragraph suggests that as each day goes by, the likelihood of compliance to save the corporation from the SEC's wrath diminishes.
Now, Mr. Sharp, you submitted a declaration in support of the emergency motion to appoint the custodian, correct?
I did.
And were the statements made in that declaration true to the best of your knowledge?
Yes, they were.
And you submitted a declaration in support of the opposition to the motion for temporary restraining order, did you not?
I did.
And were the statements made in that declaration and the exhibits attached to thereto true to the best of your knowledge?
Yes, they were.
Thank you. Your Honor, at this point, I have no further questions for Mr. Sharp.
Mr. McElhaney, I'm going to ask Mr. Sharp a couple of questions so that you can have the full scope of what the inquiry was on direct before you cross. Before I do that, Mr. Gilmore, do you intend to offer plaintiffs exhibits 1, 5, 13, and defendants exhibit 7 for admission to these proceedings?
My intention at some point, Your Honor, is to offer all exhibits 1 through 15 of plaintiff's submission. At this point in time, I only identified those few with Mr. Sharp, but it would be my intention to offer all 15 for admission into evidence.
Okay. Let's start with the ones that you've discussed with Mr. Sharp, 1, 5, 13 of plaintiffs and 7 of defendants. Mr. McElhaney, does the defense have any objection to the admission of those 4 exhibits for purposes of this hearing only?
No objection, Your Honor.
Okay, plaintiffs 1, 5, and 13 are in, defendants 7 are in. Mr. Sharp, sir, if the Everlert stocks are traded through the OTC, are they not, does that limit them from being traded on the New York Stock Exchange, or is OTC a subset of the NYSE?
No, ma'am. I guess the easiest way to explain this is to look at it as a tier system. Whereas NASDAQ and the New York Stock Exchange would be considered top tier trading platforms. And OTC Markets would be a lesser trading platform with less stringent requirements to qualify for trading on that platform.
Okay, but regulated by the SEC, just like the New York Stock Exchange.
Yes,
well, you said that there's a lower level of regulation, but it is regulated.
Ultimately, it is regulated by the SEC. However, pink sheet companies that are deemed non-reporting, like Everlert, are generally not as scrutinized by the SEC as a company that does directly report. The issue, if Your Honor will give me a little leeway, the issuance here becomes reporting style. Reporting companies report their financials directly to the SEC, and OTC Markets has less of a say whether the company is current or not. Non-reporting companies like Everlert disclose through OTC Markets disclosure system, and then it is deemed by OTC Markets itself whether the company is current in its disclosures or not. However, the SEC always maintains the power to suspend any public corporation.
Okay, all right. Okay. Thank you very much. Mr. McElhaney, your cross.
Thank you. Mr. Sharp, good afternoon. David McElhaney on behalf
Oh,
of.
I'm sorry,
Everlert.
Mr. McElhaney, I did have one more. I'm
Okay.
sorry, but this is
Okay.
important because it goes to something that you raised in your, the exhibits that you filed. Mr. Sharp, Mr. Gilmore argued today, it's not something you testified to yet, that that prior to the filing of the application with this court for the restraining order, you knew that Everlert had been reinstated with the Nevada Secretary of State, correct?
That is correct.
Okay. What impact, if any, does registration or reinstatement with the Nevada Secretary of State, as happened in this case, what impact does that have on the OTC application and the ability of Everlert to maintain their status with OTC for purposes of trading the shares?
A revoked corporation can still have their stock traded on OTC Markets or any exchange until the platform, the people who run the platform decide otherwise. OTC Markets does not have the power to suspend trading on its own. They have the power to determine whether the corporation is current or not. However, the application for access to the portal will not even be considered if the corporation is not current in its status with the Secretary of State.
Okay. If it had not been brought current, would you have been required to do that as part of the checklist of things that you've done?
I had already started the process to bring it current myself.
Okay.
Former manager.
All right. And you knew on May 4th that it had been brought current with the SEC, with the Secretary of State for Nevada, correct?
As I sit here, I don't know the date, but I did know that May 4th sounds a little early to me.
Okay.
I could check my records, but as I recall, it was much after May 4th.
Okay, but subsequent, but my notes show that subsequent to you learning that, you had the conversation with Mr. Blankenship on May 7th, correct?
Correct.
Okay.
It would have been after May 7th.
Okay.
Much after May. For some reason, the date May 24th sticks out in my head. But I could be wrong. If Your Honor likes, I can check my records and get an answer to you pretty quickly.
Right. Would you do that for me? Look at your notes and your records. Tell me when you knew that the corporation had been brought or had been reinstated with the Nevada Secretary of State.
Your Honor will indulge me for a moment.
Your Honor, Defendant's Exhibit 3 speaks to that issue, and I'm happy to have the court's attention directed to that. This is a summary essentially of the defendant's position with respect to what Mr. Sharp knew and when.
So this is the email from Mr. Blakely dated Saturday, June 12, 2021 at 5:23 p.m. to Ms. Thierry.
That's correct. And the last paragraph of page 1, Mr. Blakely represents that by May 21st, Mr. Sharp knew that the Secretary of State's office represented a reinstatement.
Okay, because he tweeted about it, right?
That's correct. So the order of events would have been the May 4 email, the May 7 phone call, the May 13 filing of the complaint, the May 14 service of the complaint, and then sometime between May 14 and May 21, Mr. Sharp was made aware that the reinstatement had occurred. The motion was submitted thereafter.
And Your Honor, I would represent that I made that tweet minutes after I discovered that Everlert had been reinstated by the Nevada Secretary of State. So the May 21st date, I thought May 24th came to my head, but May 21st is, if that's the date of the tweet, that would be the date I became aware.
Okay. Thank you very much. All right, Mr. McElhaney. Thank you very much, Mr. McElhaney.
Thank you, Your Honor. It's helpful. Mr. Sharp, my understanding is your emergency motion for application as custodian was pursuant to Nevada Revised Statute 78.347, subpart 1B, talking about the corporation has to abandon its business and has failed within a reasonable time to take steps to dissolve, liquidate, or distribute its assets in accordance with this chapter. Do I understand that correctly?
Well, I won't cite to the statute number, but if that's what it states in the complaint, then I would go along with it.
All right. Well, I want to make sure I get your understanding of why you were applying for custodianship. Is it your contention that you had a right to seek custodianship to protect the deadline from expiring for the OTC filing?
I had the, well, that was just one of several reasons.
Is there statutory authority that allows you to apply for custodianship based upon your efforts to protect shareholders?
Well, not to speak for counsel, but that would call for a legal conclusion, I believe.
Well, what I'm trying to figure out, Mr. Sharp, is what is your understanding of the authority that allowed you to apply to this court for custodianship?
The corporation had been abandoned.
Thank you.
And remains abandoned until I took over.
And abandoned in its business, correct?
By abandoned, it was at the time we filed the application, it was revoked by the Secretary of State of the state of Nevada. It was delinquent with OTC Markets and it had no performing asset.
Let me approach it in a different way, Mr. Sharp. You had filed almost an identical complaint and emergency motion against a client that we represented back in May of this year. That was Retech, correct?
I don't know if I would use the word identical, but similar.
You alleged in your complaint that they were revoked by the Secretary of State, correct?
They were revoked by the Secretary of State, correct.
And that's what you alleged in your complaint against Retech, correct?
I don't recall what I alleged in case against Retech. That was a while ago.
And in the complaint, well, let me ask this. How many actions like this have you filed, Mr. Sharp?
5 or 6.
And in those filings, on how many occasions have you prevailed and been awarded custodianship?
Objection to the relevance of this.
I think I'm sorry, Your Honor, if I may respond. Motivation is a critical aspect of this case. It is our position that Mr. Sharp is misusing the statute to locate and raid publicly traded companies so he can do reverse mergers and make money. That's what this is all about. It's not to protect shareholders. So I think it's relevant.
Go ahead, Mr. McElhaney. Objections overruled.
So you've done this on, what did you say, 5 or 6 occasions?
I will count them. 6 occasions.
Okay. And on those occasions, you filed a complaint to be appointed guardian, correct? Or custodian, rather?
That would be correct.
And you also filed in each of those cases an emergency motion to have yourself appointed, correct?
I would say on 5 of them, correct. On the 6th one, I'm not sure.
And on how many of those occasions have you succeeded and been appointed custodian?
5.
In 5 instances, you've actually been successfully appointed?
Yes.
And on how many of those occasions did the corporation show up and defend against your claim?
Twice.
All right. In all other occasions, you won by default?
Actually, 3 times. I'm sorry. The corporation defended itself 3 times, and I won 3 on default and 1 after trial.
All right. So in the Retech case, the case where we defended against your claims, You had an order very similar to the order you have in this case, correct? That appointed you custodian.
Well, I'm not going to testify as to the similarity of the order because I'll let counsel,
Well, why won't you testify to it?
because I don't recall what the retech order said at this point.
Okay, but you agree with me, the allegations in retech, and to be clear, this was just several months ago, correct?
That's correct.
And in that case, you made the same allegations that you're making against my client Everlert in this case. That is, that they had been revoked status with the Secretary of State, and they were not current with, in that case, it was their SEC filings, not OTC marketing. Does that ring a bell with you?
I would agree to use the word similar rather than same.
Okay. And in that case, you agreed to set aside the order that you had obtained prior to our being heard on the matter, correct?
That would be correct.
Why'd you do that?
The situation, I believed that retech did not have the opportunity that Everlert would have had, or the other custodian cases, to respond. As I recall, that's the way I recall. I don't totally recall everything.
So I want to make sure I understand your testimony, Mr. Sharp. What you're saying is you felt that retech had not had a real opportunity to respond to your emergency motion. That's why you agreed to set it aside?
I felt that they made a compelling argument, and I tried to be fair with retech.
Okay. And you then stipulated to set aside that order so that it could go to an evidentiary hearing, correct?
As I recall.
And sir, what happened at that evidentiary hearing? Did you prevail on your claim for custodianship?
I did not.
Why?
Well, I'm not the judge, so I'm not going to speak to that.
You don't have to be a judge to answer my question, sir. You were there, weren't you?
I was there and I lost.
And the judge determined, did she not, that the issues of revocation with Secretary of State and not being current on the SEC filings were not the determining factor as to whether or not you should be a custodian, didn't she?
I don't recall what the judge determined.
Well, let's look at Exhibit 3 to our motion to set aside the order. And I would refer the court to page 79 of Exhibit 3 to our motion.
Just give me 1 minute, Mr. McElhaney. These were not exhibits that were filed for purposes of these hearings, but that they were exhibits attached to the motion to set aside.
Yes.
Okay, just 1 minute. And which exhibit is it?
Exhibit 3, Your Honor, and it is the full page transcript, page 79.
Okay, I'm there.
Mr. Sharp, on page 79, I'll make a representation to you. I don't suppose you have that exhibit in front of you, and I apologize. I don't have the ability to put it up on my screen. But the court determined, after hearing the evidence, that the purpose of appointment of the custodian, for purposes of appointment of custodian, I look to whether or not the corporation has abandoned its business. Do you recall the court making that determination?
I do, and I believe that the management of retech had shown that they had a business.
Because the testimony at the trial was that they had ongoing business, correct?
I believe they convinced the court that they had an ongoing business, yes.
And before the court's inquiry, well, before those witnesses testified at the evidentiary hearing, Mr. Sharp, had you made any effort with retech to determine if they had ongoing business?
Yes.
And what representations did you make in that regard to the court?
don't recall.
Well, okay. Let's turn our attention. So you agree with me in Retech, you made similar allegations, not the same, but similar allegations to what you made in Everlert, that they were revoked status, Secretary of State, and that they had fallen behind on their filings with SEC. Do you agree with that?
That would be the case, yes.
And you lost at the evidentiary hearing because Judge Simons determined that at the heart of the case is, and the issue before the court is whether or not they had abandoned their business, correct?
I don't recall.
And the court determined after hearing the testimony that Retech had not abandoned its business, that it had active ongoing business, correct?
I believe so, but I'm not 100% sure.
So, sir, here's my question to you. When you talked to Mr. Mr. Blankenship, did you ask him if they had any ongoing business or if they had abandoned their business?
I don't recall.
I don't see it in your email, do you? Where you threaten him with a 48-hour deadline that he either has to get current with the Secretary of State and get current with his OTC filings, or you were going to file a complaint?
I don't believe it's in the email.
Why?
Because it's not.
Well, I will represent to you, sir, that under the statute, the only avenue, the only road to custodianship is you demonstrating that the corporation has abandoned its business. Do you know that?
Of course I know that.
Okay, so my question is, why wasn't one of your conditions in your email to Mr. Blankenship to disclose to you whether or not they had abandoned their business?
Because they weren't allowed to do business while the corporation was revoked. It would have been illegal to do business in the state of Nevada or anywhere else while the corporation was revoked.
So your decision is that if a corporation is revoked, they can't do internal business with their own investments and ongoing businesses. Is that your testimony, sir?
That is correct.
Okay.
That's my understanding.
So you concluded that because of their revoked status, they must have abandoned their business. Is that accurate?
Abandoned the business, yes.
And sir, where in your moving papers or your declaration do you make that representation to the court in this case?
I don't know. As I sit here, I don't have the complaint in front of me.
Well, you don't make that representation, Mr. Sharp. What you argue is that they are revoked status with the Secretary of State and they've fallen behind in their filings with the OTC. Those are your two bases.
Is there
it appears, I'm sorry?
Is there a question here or are you arguing with me?
Hey, let's not do that. That's not permitted.
Mr. Sharp,
Mr. McElhaney, ask your next question.
In your emergency motion at page 5, paragraph 22, you state, Everlert's status with Nevada Secretary of State's office has been revoked since 2019, and it has failed to make its disclosures to OTC Markets since 2019. In the very next paragraph, sir, paragraph number 23, you state, because Everlert appears to have abandoned its business and has failed to take steps to dissolve, liquidate, or distribute its assets, Sharp respectfully requests the appointment of a custodian for Everlert. Nowhere in there, sir, do you say anything about they can't do business because they're revoked.
So
my question is this. If the ultimate burden for you is to establish that the corporation has abandoned its business, why would you not have included that in your email to Mr. Blankenship?
As I've already stated, I made it clear to Mr. Blankenship, as is clear in my email, that the corporation has been revoked. And I'm sitting here with 1, 2, 3, 4, 5, 6 lawyers in the room. And I think everybody knows that a corporation that has been revoked cannot do business. That's my answer.
As you sit here today, do you know if Everlert has abandoned?
I'd like to supplement my answer. Also, a corporation that doesn't have a registered agent for process cannot do business. And Everlert at the time did not have one.
As you sit here today, Mr. Sharp, do you know if my client is actively engaged in their business?
I have seen no evidence that there's a performing asset. The last reported line of business of the corporation involved a incarcerated rap entertainer that I can see.
So what did you say? That you can't find evidence that they have a producing asset? I can't remember what you said.
They don't have a performing asset.
Performing asset. So is it your position, if my client has assets, let's say hypothetically, but they may not be performing or generating revenue, is it your position that that is not that is not performing their business?
I'm sorry, could you repeat that?
Sure. So is it your position that if my client has assets that they are managing, but it's not performing or producing revenue, that is not ongoing business with the corporation?
No, I didn't say that at all.
Okay. So as you sit here today, can you tell the court definitively whether or not my client has ongoing business?
I see no evidence of any ongoing business.
It's not my question. Have you asked?
Whether asked who?
My clients, Mr. Blankenship or Miss Harper.
Wouldn't have had a chance to. He hung up on me during our phone conversation, so I wouldn't have had a chance to.
Was it of any concern to you at all, whether or not they were doing business?
Well, they can't do business while the corporation's revoked.
Thank you, Mr. Sharp. That wasn't my question, though. Is it any interest to you whether or not they were doing business?
Well, I would have assumed that your clients who would wish to be law-abiding would not do business while the corporation was revoked. It's not.
I'll ask the question again, Mr. Sharp. Was it of any interest to you whether or not my clients were doing business?
No.
Okay. So your approach, as I understand it, in your emergency motion to have your self-appointed custodian was, it had really nothing to do with whether or not my client was doing business or had abandoned its business. It was more an issue of you were there to advocate for the shareholders and to protect them so that the deadline for the OTC filing didn't expire. Do I understand that correctly?
One more time, please.
Sure. My understanding is in your application to be appointed custodian, you felt the basis for you making that application was to advocate for the shareholders and protect them from the expiration of the deadline with the OTC filing. Is that accurate?
Well, and to have a current corporation, but ultimately, yes, the shareholders need to be protected.
And whether or not the corporation had or had not abandoned its business was an irrelevant concern to you.
Well, the question then becomes which business, because the corporation had like 8 lines of business under the current management.
Say that again, please.
Corporation had 8 at various times, 8 different lines of business. 8 might be the wrong number, but several different lines. It changed business lines of business on a continuing basis.
How do you know that?
Because I've followed the corporation's press releases and representations to OTC Markets.
So is it fair to say that when you filed your motion for custodianship, You knew that the corporation had ongoing businesses, didn't you?
No, that's not true. That's not what I said. What I said was that they represented they had businesses while they were still reporting to OTC Markets and the shareholders. Then they went quiet for 3 years. So nobody knew anything.
So to be sure, just to make sure I'm clear, you knew they had businesses, but whether or not those businesses were active or had been abandoned, you had no idea.
I knew they had businesses, purported businesses, once upon a time. But as they were delinquent in their responsibility and fiduciary duty to the shareholders, I had no idea whether there was anything ongoing, and nor could there have been anything ongoing because the corporation was revoked.
Okay, but what you're telling me is you're making a legal conclusion. What you're saying is, look, I really don't know if they had ongoing businesses or not when I filed my application. However, I felt that they were not allowed to engage in any business because they were revoked. Have I accurately summarized your testimony?
I would say to you that if they had any ongoing businesses, they were conducting them illegally, and that they were revoked by the Secretary of State, and that's why, and they were delinquent with OTC Markets and several other necessary entities, and that's why I filed for custodianship.
Okay.
Oh, and as Mr. Blankenship didn't respond in the affirmative to my inquiries.
I don't want to beat a dead horse here, but you never asked him, by the way, are you doing business, whether it's illegal or otherwise?
No, I offered to let him reinstate the corporation and file an application with OTC Markets. He didn't do it.
It's not my question, sir. I just want to make sure the record is very clear. Did you ask him if the corporation was doing business?
I don't recall.
When did you buy stock in Everlert?
Mr. McElhaney, if I can do this, sir, this feels like a natural transition. I do want to take some time off the record. We've been going almost 2 hours and our court reporter hasn't had a break. So let's do this. It's 4:50. Let's take a 15-minute break. We'll be off the record until a few minutes after 5 o'clock. Counsel, just so you know, my goal is to get this done tonight. So if you had dinner plans, you might want to make some calls. We'll be in recess until 5 after 5.
Ms. Kate, if you can check your email, let me know. Thank you.
Madam Clerk, can you hear me and see me?
I can. You did drop off for a little bit there. I hope that was all right.
Yeah, no, and I have no idea. I didn't touch anything. I didn't do anything. It just spit me out.
Unfortunately, that tends to happen with technology. I feel like as many people come on, other people get kicked off, you know, as the day goes on. So hopefully you stay on for the remainder.
So I've got an airplane that I have to get on at about 6:30. I'm not making that airplane, am I?
I cannot confirm nor deny that. Unfortunately, that's your call.
Can we take a 5-minute? Can we do the 5-minute intervention motion?
I wish we could, sir. I wish we could. But if your plane is for somewhere good, I'll take it.
No, I'm going. You're not.
Okay, fine.
My wife would not be thrilled if you arrived instead of me.
You don't know. She's never met me.
I promise.
All right, sir. I'm going to take a quick
Take
break
that one
here.
to the.
All right. I'll see you shortly. Thank you.
Thank you. How long are we off? Oh.
Judge said a couple minutes after 5.
A couple minutes after 5. Ay, ay, ay.
Yes, she did say about a 15-minute break.
Okay.
All right. Thank you.
What time's the flight go to Santa Barbara? I know, so what's it leave? 9 o'clock? I thought you were gone.
Okay, so I'm just gonna go back. Okay. Yeah.
Say it again.
Hey, Mike. Right. Right. Okay. But hold on. I gotta be careful. Because if I say that to this council, then they're gonna sue me for malicious prosecution. Okay. But that doesn't explain why I said it's not agreed to set aside the application. The reason I agreed to set aside the application there was I had no communications. Here I have communications. I did.